Pech this evening. Before telling you about a few of his accolades, his very many accolades, I just wanted to make the point that this event this evening is part of a series of events that are being hosted this year to mark 50 years of Ireland's membership of the European Union. So if tweeting is your thing, the hashtag is EU50. And if you're interested in that area, if you use that hashtag, you'll find out about kind of other events that are being organised to commemorate 50 years of Ireland's membership of the EU. So I suppose it's fitting that if we think back to the 1970s when Ireland became a member, parallels with today, economic crisis in Europe, conflict within and on its borders. So, we may have made progress in some areas, but certainly not in all. And the topic of our lecture tonight, which is promoting and safeguarding EU values at a time of increasing autocratisation, is an issue that has, I suppose since about 2012, Laurent will talk about this, been kind of at the forefront of issues of concern in the European Union. And so Professor Laurent Pech, who is the Dean of Law and head of the Sutherland School of Law at University College Dublin. He's also a visiting professor at Bordeaux University and senior research fellow at the Central European University Democracy Institute in Budapest. He is also co-director of the Good Lobby Profs, which he co-founded in 2021. And the Good Lobby Profs is an NGO that believes academic expertise can be mobilised and should be mobilised to counter major rule of law violations and abuse of power across Europe. So it is a very pressing issue, I think, that is the topic of discussion for this evening. And so I'm very pleased to welcome Laurent back to Galway. Thanks, Laurent.
Thank you very much, Edel. It's very nice to be back, even though I'm afraid that the topic of tonight's lecture is not going to be very uplifting, but we may as well be aware of what's happening and what can be done and what has not been done and what can be done about it. I'm a law professor, so tonight's presentation is going to be mostly legal in nature. So I'm going to tell you about the promotion and safeguarding of EU values by EU institutions, but primarily from a legal point of view. You can, in the Q&A, you can ask me non-legal questions and I may attempt to answer, but my area of expertise is EU law and respect for the rule of law in the EU legal space, but also have a good expertise regarding respect for human rights and respect for democratic principles within the European, what I call the European legal space, meaning not only the EU legal order, but in fact the Council of Europe legal order. I think I have about 40 minutes to address this issue, so I'm going to have to simplify to some extent, but again, you can always ask me follow-up questions and then I can be more specific in my answer. I have divided my lecture into three main parts. As any good lawyer, I'm going to start with the legal framework. So I'm going to go through the main treaty provisions regarding EU values so that we are clear before I move on to part two of the talk, which is going to be about autocratization in the EU. What do I mean? What are the concrete examples of autocratizing countries in the EU? And the third and final part of the lecture is going to be on what the EU has done or not done in the past 10 years. Let me begin with the EU. What do we mean by EU values in the EU treaties? And actually, I must say the treaty framework has changed quite substantially in the past 30 years. So I've been working on this issue for about 25 years. So I suppose I've been able to keep track of the evolution of the treaty framework quite well since. The most important treaty provision when it comes to EU, what we call EU values, doesn't mean that these values are not shared beyond the EU, but I'm going to stick to the EU treaty framework. And by the way, since I'm not assuming all of you are EU lawyers and read the EU treaties before going to bed, as you should, because it's actually a riveting reading. Actually, relatively straightforward, the TEU by comparison to the TFEU, but the EU is based on two treaties, the Treaty on the European Union and the Treaty on the Functioning of the EU. So what we're looking at here is Article 2 of the Treaty on the European Union. So it shows actually the mere fact that this is the provision after Article 1 of the Treaty on the European Union shows the importance, at least symbolically speaking, which is attached to this notion of values on which the EU is based. What you're looking at here is the version post-Lisbon Treaty of Article 2 TEU, but this is not the first time. The Treaty of Lisbon did not actually lead to this provision. This provision has been in the rule book since the early 1990s. So after the fall of the Berlin Wall, the masters of the treaties, that is the EU member states, decide that it would be important to codify the values on which the EU legal system is based. And in those days, 3 values were mentioned, the same values which actually condition membership of the Council of Europe, and these are democracy, the rule of law, and respect for human rights. The fact that these values were not codified in the EU treaties didn't mean that before that the EU were not in compliance or was not trying to comply with these values. It was simply not thought necessary to codify them in what is, in a sense, the EU's constitution. And in a way, there was no need to codify these values because all the member states of the EU are also members of the Council of Europe, and the treaty establishing the Council of Europe does explicitly mention that you cannot be a party to, for instance, the ECHR if you don't comply with, if you're not a democracy based on the rule of law, respecting human rights. Technically speaking, actually, the first time this trinity of values was mentioned in an official EU document, that was in the early 1970s. But not until the fall of the Berlin Wall was it thought necessary to insert what became a post-Lisbon Treaty, that is 2010, Article 2 TEU value. The main impact of the Treaty of Lisbon was to add, or one may say inflate, the number of values on which the EU is officially based. Before the Treaty of Lisbon, there was only a mention to democracy, the rule of law, and respect for human rights, but you can see by yourself, you look at the text now, and you can see additional values mentioned, pluralism, non-discrimination, and also the rights of persons belonging to minorities. One interesting legal question, maybe interesting if you have an interest in the issue as I do, before the Treaty of Lisbon, EU values were referred to as EU principles. So some of us have spent some ink discussing whether we should in fact attach any legal importance to the fact that there was a change in wording. Is a value of the EU the same thing as a principle of the EU? As far as I know from the history of the treaties and from talking to drafters involved in the EU treaties, in fact, they didn't attach any legal significance to this difference in terminology. In fact, in other aspects, in other parts of the treaties, they refer to EU values as EU principles. So what I'm talking about is EU values, but the notion of principles in EU law is quite synonymous. So the rule of law is both a value on which the EU is based, but also a principle of a legal nature. I shall come back to whether EU values are actually justiciable from a legal point of view. But long story short, we have a number of values, foundational values in the TEU mentioned, and another treaty provision which is important to mention in this respect, I don't know if you heard of it, it's Article 7 of the TEU. I will mention it a bit later. But this Article 7 was also added to the rule book in the early 1990s. It has been described as the EU's nuclear option. I don't know if you've come across this expression of EU's nuclear option. Why? Because theoretically speaking, when a member state is systematically in violation of EU values to be found in Article 2 TEU, you can suspend the voting rights of the national government acting in the Council. This has never been done, and this has been described as the EU's nuclear option. However, there is a not-so-nuclear option also in Article 7 of the TEU, which is a preventive mechanism when there is a systemic threat to EU values, and perhaps it's worth mentioning that as of today, 2 EU member states are subject to this procedure, which is supposed to be exceptional. These two countries are Poland since December 2017 and Hungary since September 2018. In those days, most people assumed that Article 7 would never be activated. That was wrong. And that was the same year, actually, by pure coincidence, that another famous or infamous provision of the TEU was activated, Article 50, which is the process where essentially the treaty provision governing the withdrawal process from the EU. So the UK left the EU, or at least activated the withdrawal process the same year Article 7 was activated in respect of Poland. The two countries remain subject to Article 7, and in 2022, actually, these two countries have also become subject, Poland and then, since this year, Hungary are also subject to the exceptional monitoring mechanism of the Council of Europe, which is also something, or was something unexpected, at least if you take as a starting point the dominant understanding in the 1990s, when Article 2 and Article 7 were first inserted in the rule book. The assumption was it's enough to have Article 7 in the rule book to make sure that member states would be dissuaded from engaging in democratic and rule of law backsliding, and, which is what essentially I mean by autocratisation. But I will go back to this notion because I have more treaty provision to tell you about, which is great because then you can play a TEU quiz later with your friends at the pub. Said, what, Article 2, what is it? Article 49, TEU. So EU law is quite fascinating in terms of leading to fascinating quiz questions, if you ask me. But to go back to my slide, Article 49 TEU, this is the treaty provision which is addressed at EU candidate countries, and you can see an explicit reference to Article 2 TEU. So long story short, what does it mean? Theoretically speaking, it means you cannot join the EU unless you commit yourself to promoting EU values and complying with them as part of the EU's enlargement process. The commitment to promoting them, this is actually something new post-Lisbon Treaty. Before, you had only, so to speak, commit yourself to complying with EU values as part of the enlargement process. Since Lisbon, you have also a commitment to promote them once you become a member state of the EU. As of today, we have quite a few EU candidate countries. They have to show compliance with EU values within the rather technical framework, which can last years, 10 years, 20 years. There is no time limitation when it comes to the enlargement process. You won't get in until you comply with the so-called EU's acquis, including compliance with Article 2 TEU values. The last two EU candidate countries which were given this official status are Ukraine and Moldova, if I remember well. Since June 2022, and I think we have a total, I guess I didn't come with any notes, so, but I think you can correct me during the Q&A. I think we have a total of 7 candidate countries. And then I speak under supervision. Dr. Hughes, Turkey is the oldest candidate country, has been subject to the EU's enlargement process for quite some time. I'm not going to give an exact figure because I don't remember it. But the last 2 EU candidate countries are Ukraine and Moldova. Being given a status of candidate country doesn't mean you're going to ever become a member state of the EU, but it means the enlargement process, essentially the technical supervision from the EU can begin, and some of the EU acquis is directly connected to Article 2 TEU values. And perhaps worth mentioning is since enlargement process has been deemed to have failed to guarantee a good compliance with EU values in the light of the situation in Hungary and Poland, there have been methodological changes when it comes to assessing compliance with EU values as part of the enlargement process. I'm not going to go through all the technical details, but the EU Commission has tried to make it a bit more demanding so as to create a long, sustainable change when it comes to compliance with EU values. So there is no backsliding post-enlargement. Sadly, this process or the technical changes which have been made have failed to make a meaningful impact so far for many different reasons I'm not going to get into. But something perhaps worth mentioning for students here, there are a lot of jobs connected to EU enlargement policy. In fact, one of my first jobs when I was a PhD student was essentially paid for by the EU. I was paid to work as a lawyer in Bosnia. And that was indirectly part of these financial instruments which are dedicated to getting a number of countries ready for EU membership. So something also important for the students who are possibly now doing a master's degree in human rights law. So perhaps you may not be aware of the fact that as part of the EU's enlargement policy, the EU has a very sizable budget which is dedicated to promoting compliance with EU values, especially in EU candidate countries, and they rely on a lot of consultants and junior experts especially. In fact, there is a lot of funding also connected to Article 21 of the TEU. This is the provision which is aimed at non-EU countries, third countries in EU speak. So these are countries not wishing to become member states of the EU, otherwise then they'd be subject to Article 49 TEU. This is for countries like, for instance, the United States or the UK now. The EU's action on the international scene shall be guided by a number of principles, even though Article 2 TEU is not explicitly mentioned. These principles include democracy, respect for the rule of law, respect for human rights, and also additional principles such as compliance with international law. On the basis of Article 21 TEU, there are a number of EU legislative instruments which have been adopted by EU institutions. And then again, there is a very significant amount of money dedicated to external promotion of what can be described as EU values, but also to be found also in the UN Charter. So this is again, it does make possible the recruitment of many experts in worldwide actually, because the Commission, for instance, has delegations on a worldwide basis. And so, for instance, you have human rights officers in EU delegations. Most of the promotion work is done actually through financial instruments. I mean, I don't have time to go through all the instruments which are used to promote promote these values, but most of them are financial instruments, meaning that you have financial assistance available to third countries to pay for technical expertise, technical support, or including sometimes better access to the EU's market in exchange from undertaking a number of steps which are essentially connected to the principles mentioned in Article 21 TEU. Article 21 TEU, by the way, is brand new post-Lisbon. It did not exist before Lisbon Treaty, but it does merely codify the previous practice. But this is a brand new article which makes clear, for instance, that the EU cannot act in violation of the UN Charter and principles of international law, which is not always recognized in national constitutions of EU member states. I'm going to end part one of my talk with some recent developments which I thought would be of interest, especially if you're a lawyer. Because of what's happening in Hungary and Poland, we have seen some interesting conceptual challenges targeting Article 2 TEU values. And I just have to summarize, so I'm just to name one. What we have seen, quite interestingly, in the past few years is that national governments of Poland and Hungary have started questioning whether EU values actually exist, whether they're not, in fact, meaningless values because they have no specific content. And they have also questioned whether they are justiciable. So, for instance, just to give you, you have a quote here regarding the rule of law itself, which is my favorite concept, which has been my favorite concept for many years. And Polish authorities and Hungarian authorities have been essentially in the past few years saying the rule of law is an open-ended concept, meaningless, doesn't exist, and if it does exist, it cannot be legally defined. So you have the example of what Orban's Minister of Justice said in 2019, the rule of law is a buzzword, essentially. Most recently, after what the ECJ said in 2022, said, even if it's not a buzzword, she said, after the election, she said, a democratic mandate, it's not an exact translation, overrides everything and gives the right answer to anything. This is actually a good example of populism. Democratic mandate, no matter how rigged the elections, gives you a mandate to do whatever you want. But that was, in a way, possibly an indirect reaction to what the ECJ stated in two important judgments this February. In respect of the so-called rule of law conditionality regulation, I will end today's presentation by telling you a bit more about the rule of law conditionality regulation. But what is interesting at this stage to state is that for the very first time, the court confirmed that, I mean, it's not surprising what the court stated, but at least for the very first time, stated explicitly that Article 2 values constitute the very constitutional identity of the EU, and that these values are in fact all justiciable, all legal principles. So they are not open-ended, they are not meaningless concepts. In fact, they've been given very specific legal meaning through legislation and the case law of both the Court of Justice and the European Court of Human Rights, and also, in some instances, the case law of national constitutional courts, of national Supreme Courts. But bottom line, the Court of Justice could not have made it clearer that it does not agree with the conceptual challenges arising from Warsaw and Budapest. If this is of interest, my latest article is precisely about this very debate. It's, the title of my latest article is The Rule of Law as a Well-Established and Well-Defined Concept of EU Law. So, in fact, I'll, on the back of this judgment, engage with the conceptual criticism coming from the so-called illiberal regimes of Poland and Hungary. Another interesting aspect of the judgment is, for the first time, the Court of Justice made clear that the EU does not simply have a duty to comply, promote, support Article 2 values. It has a duty to defend Article 2 values. This judgment, or the two judgments of the Court of Justice, have been understood by some as the Court of Justice making clear for the first time that the EU can and should behave as a militant democracy in the same way that German and Italian authorities used to handle autocratic, authoritarian challenges internally. So the EU can and must be a militant democracy, but obviously within the powers, within the limits of the powers laid down by the treaties. But this is quite new, the fact that the Court of Justice has used the concept of constitutional identity with reference to Article 2 values. Whether this is right or wrong, I leave it to you to decide. But quite clearly, from the point of view of the Court of Justice, Article 2 values are not simply political principles, they are legally binding principles. They bind EU institutions, they bind everyone in every single member state, and EU institutions simply must not simply comply with them, they have a duty to defend them when they are under attack, especially from national authorities, as I shall now demonstrate by giving you an overview of democratic and rule of law backsliding within the EU. So the legal assessment of my talk is now going to finish. It's going to stop for the next 5 or 10 minutes, and then I'm going to return to more legal aspects. So I just wanted to give you an overview of the situation and how bad it is, because surprisingly, not everyone is fully aware of what has been happening in the EU legal space for the past 10 years. But before returning to the EU, actually, the situation worldwide is not great. It's quite bleak, actually. What you're looking at here is the latest findings from the so-called VDEM Institute, which is based in Sweden. So mostly political scientists assessing the state of democracy on a worldwide basis. They publish every year an annual report, which is entitled the Democracy Report. So you have the Democracy Report 2022 findings on the slide. And the picture is quite bleak because essentially autocratization is on the rise everywhere. So it's not simply, obviously, democratic and rule of law backsliding. What's happening in the EU is the broader picture is the same. Actually, autocratization is on the rise. And this is new since essentially has been the case for the past few years. In the EU itself, and quite depressingly, for the first time, the VDEM Institute referred to a so-called wave of autocratization happening, unfolding in the EU. Beyond Hungary and Poland, 4 additional member states were identified as being on a backsliding pattern. These 4 member states at the time were Slovenia, Croatia, Greece, and I'm forgetting the 4th one. He'll come back to me eventually. Or perhaps I should make this a quiz test. You have to go online and identify the 4th EU country. I have a map, so we'll find out soon enough. So this is a wave of autocratization in a geographical map here. I have even more depressing news to some extent. The VDEM Institute has always a top 10 of the world's top autocratizing countries, so backsliding countries essentially. And it is a depressing picture because just a decade ago, in 2012, I think, the EU was given the Nobel Prize for its work on promoting democracy, respect for human rights and the rule of law. A few years later, the world's worst autocratizing countries in 2020, Poland and Hungary. And in top 5, you have 2 EU candidate countries, Turkey and Serbia. According to VDEM Institute, even more depressing, Serbia, Turkey, and Hungary are not even anymore democracies. So technically, enlargement negotiations should stop because, or at least they're never going to conclude as far as Serbia and Turkey are concerned, at least until they are still in this backsliding pattern. Now, what is interesting is that very recently, for the very first time in the history of the EU, as far as I know, one of the main EU institutions formally accepted this diagnosis by EU institution, I mean the European Parliament. So the European Parliament in September 2022 adopted a resolution as part of the Article 7 proceedings against Hungary. And in this resolution, for the very first time, the European Parliament accepted that one of the EU member states is no longer a democracy, therefore in open violation of basic membership conditions. Because normally you cannot be a member state of the EU if you're not a democracy, because that's an open violation of Article TEU foundational values. Now, this does raise a number of interesting between quotation marks, of legal and political questions. Legally speaking, for instance, technically, decisions adopted by the Council can only be adopted by governments democratically accountable to their parliaments or to their citizens. So theoretically speaking, one make the argument that every decision adopted, every piece of legislation adopted by the Council of Ministers with the support of the Hungarian government is in violation of the TEU. The good news for the Council is that no one has legal standing ready to sue apart from the main EU institutions, and no one wants to open this kind of worms. But this does raise a serious legal and political questions, because also of plenty of other principles, such as the principle of mutual trust and mutual recognition of judgments. Why should an Irish judge recognize the validity of an Hungarian judgment, since according to the European Parliament, the Hungarian judgment is from a country which is no longer a democracy? So it does raise plenty of potential headaches with a direct impact actually on concrete cases. I've been involved myself in a series of extradition cases regarding surrenders to Poland. Poland is not yet considered a non-democratic member state, but should become the EU's second authoritarian member states of the EU within the next 2 to 3 years based on the current pattern of development. So this is actually bringing plenty of questions we never thought EU lawyers would have to discuss. What is a court? When should you stop complying with judgments from bodies calling themselves court, but which are in fact not courts within the meaning of EU law? So the situation is quite dire, and in fact this has been recognized for the very first time last year and this year by the 2 presidents of Europe's 2 supranational courts. This is what you're seeing now is completely unprecedented. I had never heard the president of the Court of Justice of the EU mentioning he explicitly stated that he was worried about the very survival of the European project and spoke of the dismantlement threats to the very foundation of the EU from the point of view of the rule of law. And interestingly enough, a few months later, the president of the European Court of Human Rights, or the former president of the European Court of Human Rights, because the current president is from Ireland, a UCD law graduate, if I'm not mistaken. The former president of the ECHR, Robert Spano, from Iceland, gave a very powerful speech, again, where he spoke about the risk of rule of law disappearing from within the European legal space. These 2 speeches were unprecedented. It's very rare for a sitting president to be so obvious, so blunt. Essentially, you can understand these 2 speeches as being addressed to the relevant political institutions and say, you have to do something. There's so much we can do as independent courts. Sadly, as we shall now see, and this is the third and final part of my talk, and I'm not going to mention what has been done or not done by the Council of Europe's institution because I don't have time, but so I'm not even going to engage with the case law of the European Court of Human Rights, even though it'd be quite interesting, but you can invite me again maybe next year. I'm going to tell you about what EU political institutions have done, or rather not done. And I'll keep it rather brief because I think time is flying. So I'm going to give you an overview of what has been done or not done since 2012. And why have I picked 2012? Because this is the first time there was an explicit recognition by the sitting president then of the European Commission, President Barroso, that there was a new type of threat to the democratic and rule of law fabric in some of our member states. In those days, 3 member states of the EU were in the news: Hungary, Romania, and France. I'm not going to go through the factual background to this, but essentially this is the first time there was an explicit acknowledgement that the EU was facing a new type of threat for which possibly the EU system of remedies or the EU's institutional framework was not ready. Now, I believe this diagnosis to be partially flawed, but this is not the time to debate whether this was right or wrong. What is interesting to note is 2012 was really the first time EU institutions understood there was something unusual happening, and this something is what I have described before: democratic and rule of law backsliding, even though this notion of backsliding actually did not take off until the past 2 years or 3 years. So it took an additional number of years for the EU institutions to actually even speak of backsliding or constitutional regression. And it took until 2022 for the European Parliament to acknowledge that one EU member state, sadly, is no longer a democracy, or the European Parliament described Hungary as a hybrid regime, so aka electoral autocracy, meaning that it looks like a democracy, but they no longer have free and fair elections, and the system of checks and balances has been completely undermined, so much so that you just have essentially what is a fake democracy, simply, a kind of a Potemkin-style democracy, sadly. Returning to 2012, what was done? The Commission created a new tool, which is called the pre-Article 7 framework. It doesn't really matter because I want us to focus on the big picture. And this is essentially kind of my attempt to summarize what the main achievements, or not achievements, I say the main changes adopted by the EU institutions. So what we have seen in the past 10 years is the EU institutions have adopted plenty of new schemes, new tools to address compliance with Article 2 TEU values internally and also domestically. When it comes to democracy, for instance, and I've just given you a recent example, for the very first time, recently, the EU Commission adopted a European Democracy Action Plan. What is new? This is oriented towards existing EU member states. We had plenty of democracy and human rights action plans before, but they were always for non-EU countries. So for the very first time, the Commission at least has acknowledged that there is an issue with democracy within the EU space itself, and a number of legislation or legislative pieces of legislation are now pending or being discussed. For instance, they're looking at the funding of European political parties to better guarantee compliance with EU values. They're discussing a new Media Freedom Act. They're discussing a new legislation to prevent SLAPs, strategic lawsuits against public participation. So this is new, but it is first and foremost a kind of action plan consisting of pieces of legislation. When it comes to fundamental rights, actually, not much was done internally because the main focus was on the situation externally. So a lot of funding was made available to actors working on the situation externally. But this has changed also recently with a new strategy when it comes to the internal application of the EU Charter for Fundamental Rights. But again, this is mostly a kind of an administrative monitoring process. This time, no legislation actually connected to this strategy. Rule of law is the one principle, the one value which has got most attention internally. Externally, for some reasons, the EU actors have been less keen to promote respect for rule of law, so the focus has been in external actions on democracy and respect for human rights. Internally, the focus, however, has been very much on the rule of law since 2012, so much so that now we speak of the so-called EU's rule of law toolbox. There are so many new tools. In fact, I could speak on the tools for days. We can have a summer school on the EU's rule of law toolbox because there are so many tools. The last two are mentioned on the slide, the annual rule of law report and the famous EU's rule of law conditionality regulation, which has been activated for the first time this year in respect for Hungary. Actually, this is decision week. Currently, Hungary is under threat of seeing 6.5 billion euros suspended. It won't happen, I can tell you already. At least that's my prediction, sadly. And the rule of law conditionality regulation is yet to be activated against Poland. Then there is this annual rule of law report this time, which applies to every member state. And in fact, I have included in my next slide the rule of law recommendations addressed to Ireland, just for your own interest. When it comes to democracy and fundamental rights, there is no specific Irish document, which I thought would be interesting to share with you because there is none. It's mostly aimed at everyone. So when I told you about the new forthcoming legislation on SLAPs, it's going to apply to every member state, including Ireland. And possibly it's a good thing this is also happening because Ireland, in fact, according to the latest annual rule of law report, has a problem when it comes to SLAPs. Especially in the context of environmental litigation with environmental relating NGOs being subject sometimes of threats in the form of a strategic lawsuit, or even a threat of a lawsuit is enough to bully people into submission. Or create what is called in European human rights law a chilling effect. So since this year, every country has a number of recommendations addressed to the authorities, and you're looking at the relatively short list of recommendations, rule of law recommendations addressed to Ireland. Even though the title of the report is Rule of Law Report, actually rule of law in this context is understood very broadly. It has a human rights aspect. It has democratic aspects also because media pluralism is reviewed as part of this annual Rule of Law Report. So rightly or wrongly, so conceptually speaking, you can disagree that this is part of rule of law principles, but I suppose for efficiency reasons, it was decided to use rule of law in the title, but in fact it's very much all Article 2 values being reviewed every year. Actually, starting today, you can feed into the process. So every winter, the Commission is going to gather feedback about the rule of law, broadly understood, situation in every member state. So starting today, there is a questionnaire available from the Commission, and you have a few weeks to eventually submit your answers back to the Commission. And next year, the report regarding Ireland will include information on whether these recommendations have been complied with or not. From a rule of law point of view, perhaps worth of attention, the only really worry of the Commission is concerned the composition of the new judicial appointment commission, which is, I think, still not yet adopted. And then there are just usual problems which you would find in most countries, even though litigation costs are actually higher than average in Ireland. That being said, I have some good news for you. You can be proud. You can come out of this lecture feeling proud to be Irish, because according to the World Justice Project Rule of Law ranking of this year, this is from 2 weeks or 3 weeks ago, Ireland is in the top 10, both from in the EU, FTA and North America grouping, but also worldwide. So you may disagree, you may agree. This is based on polls and expert submissions. So Ireland is doing quite well, especially if your point of reference is the rule of law situation in Poland and Hungary, where the issues are systemic and where we're talking, in fact, about a deliberate top-down process of dismantlement of checks and balances. This is what I have described in my scholarship as rule of law backsliding, but you can describe it also as the Article 2 backsliding in a way. And so on this note, a positive note, I would like to conclude, and I'd be happy to answer any questions you may have. Thank you.
So I'm just going to say thank you, huge thank you to Laurent for an excellent lecture. Somewhat disturbing, but I think, as Laurent said, it's important to reflect on the threats and to be aware of them. I think it's also interesting to reflect on whether or not we're backsliding or making progress, or when we think about the European Union as having values at its heart, was that always the case? Can we look back a few decades and think of parts of what were within the European Union facing very significant rule of law and human rights threats? And perhaps less so now. So there's a forward and back, I think, at different points in time, and also just listening and reflecting. I think the comments there about, what do we think of as being at the heart of the rule of law? So rule of law is also engaging questions of human rights more broadly, and thinking about the extent to which gender equality, gender inequality, women's rights, LGBT rights have been so threatened. But have been in the past also, and we see movements forward and back around that, and thinking about Ireland at the European Court of Human Rights appealing to distinct moral sensibilities, the will of the people, which of course was not in fact reflected. I think there is much there that we need to think about also in terms of the toolbox and how that works or doesn't work. And to what extent political activism, politicization, the will of the people more broadly in terms of political movements can also be a way of enshrining rule of law. And when rule of law is under threat, perhaps the will of the people expressed through political movements and human rights activism can also be a way of protecting the rule of law. But anyway, just to say a huge thank you to Professor Pech. I hope you'll be a regular visitor now that you're back on the island of Ireland. And thank you very much for delivering the lecture on the European Union at 50, reflecting on this core question. And a huge thank you to the organizer of this evening's event, Dr. Edel Hughes, lecturer here in European law, who's bringing these questions to us every day in terms of teaching and research and advocacy. So thank thank you very much again. Thanks.
In person.